Hi, this is Kevin Baldwin from Baldwin and Vernon, Attorneys at Law in Independence, Missouri. Today I want to talk to you about arbitration agreements and what they are and how you might be subject to one without even knowing it. First, let's start with the American legal system. One of the things that the Americans, the colonists, our founding fathers asked for in the Declaration of Independence to the king, when they filed that complaint against the king, they said they wanted trial by jury. They want trial by jury for civil claims. That was one of the demands in the Declaration of Independence. Later, when they made the Constitution of the United States, the Seventh Amendment to the United States Constitution is the right to a civil jury trial for any controversy in excess of $20. Now, back then, $20 was a lot of money. But you have that right. Under the law, in a civil matter, you have had the right to bring your case before a jury and have the facts determined by the members of your community. Unfortunately, in the last several years, arbitration agreements have been employed by companies to try and subvert that process. And here's what I mean by that. Arbitration is where you have agreed contractually to give up your Seventh Amendment right. You have agreed to give up your constitutional right and to have your claims against your employer submitted to a third-party arbitrator. Now you might say, well, why is that a bad thing? Isn't that like a judge? No, it's not like a judge. Arbitrators are private individuals and private organizations. The nice thing about a judge is a judge usually is either elected or he's on that bench for life, which means he is unbiased. He is straightforward. And anybody that comes before him, all they have to do is file their filing fee to file their claim with the court. And that could be a few $100s. And once you do that, you get to start in what is the engine of our justice system in America. Arbitration is different. Now, companies have foisted arbitration on people by claiming, oh, it's cheaper, it's easier. No, it's neither one of those things. Well, it is cheaper, but it's cheaper for the company, meaning that you are far less likely to get a significant recovery from an arbitrator than you are from a jury. A jury may hear your facts and be outraged and say, we cannot allow that in our community. We want to send a message. So we're going to give you X number of dollars for your actual damages, for your lost wages and your emotional distress, and then we're going to hit them with punitive. We don't want them to do that anymore. Arbitration takes that all away. Now, you might still be able to get the punitive damages, but the problem is with arbitration itself. Oftentimes, it is a shortened version of a trial. Also, the arbitrators list themselves. Most of them were former big defense firm people, and they often don't give large awards. In fact, one of the problems that I think myself and other plaintiffs' lawyers have with them is that they rely on those companies to pay them. More often than not, part of the arbitration agreement is that the company will pay for the arbitrator. Sounds great, but do you really want to put your fate of your claim and your rights in the hands of somebody who's being paid by your former employer? No, you don't. In addition, those arbitrators want to keep arbitrating. Now, who's going to have more arbitrations, you or the company? The company will, because they have claim after claim after claim. So then it just begs the issue of, can the arbitrator truly be fair and impartial? Or are they trying to curry favor with this company? In curry favor, they might either find against you, or in an egregious case, they might award damages in your favor, but they might be a lot different than what a jury would give you. They might be a lot less. Now, there's always a few outliers where an arbitrator has awarded a large sum of money. It's been my experience when I see those arbitrations, that company will usually never agree to use that arbitrator again. Now, let's talk about arbitration for a minute. How did you end up in arbitration? How do you not know you're in arbitration? Well, the problem with that is arbitration has been used in the past by unions, union arbitration, but that's a good thing because unions engage in what's called collective bargaining, and they have power, the power of a union. Most of them, their claims are taken through the arbitration provision. However, certain things are taken out of arbitration, such as any type of sexual harassment claim or age discrimination complaint that you might have against the employer in general. that is not handled by arbitration. It can go through arbitration, or you can take it to a court of law. That's fantastic. Also, professional athletes often have an arbitration clause in their contract regarding damages, if they're cut or if they're injured and how much money is owed them, whether or not they have an escape clause or the team tries to get rid of them for non-conforming actions such as domestic violence, things like that. And that's fine. Those are all covered under arbitration because the parties equal bargaining. More often than not, if you're an employee, just a regular employee at a large corporation, you signed an arbitration agreement at the time you came on board the company. And many times you don't even know what you signed. What you agreed to sign at that time was to waive any and all claims that you might have under the Title VII of the Civil Rights Act of '64 for sexual harassment, gender discrimination, race discrimination, national origin discrimination, religious discrimination, or age discrimination under the ADEA, or even disability discrimination under the ADAAA. Also, it goes to state causes of actions as well. Oftentimes, it is any employment claim you could make under the law. You have now waived the right to file a lawsuit, and you're in arbitration. Again, the problem with that is most people don't know that's where they're at. In addition, secrecy can be an issue. And we learned about that most recently in the last several years with the Harvey Weinstein issues. Whenever he had a complaint lodged against him, a lot of times those happened in arbitration, and the people were never allowed to say what happened or what he was doing. More famously, I think, was Gretchen Carlson and Fox News. Fox News made all of its people sign arbitration agreements. Now, she actually ended up outside of arbitration. But the problem is the process is so secret that we'll never know how her lawyers got her out of the arbitration agreement. But she has now taken a stance against mandatory arbitration for employees. Problem is if you have an arbitration agreement, it does materially affect the value of your case. Also, whether or not you can bring your case, where you can bring your case, and when you can bring your case. So one of the things you want to find out first and foremost, even before you file a charge of discrimination, is do we have an arbitration agreement? Look to your policy manual. Oftentimes your policy manual will refer to it. Now the funny thing is, you generally don't have a contract for employment. Here in America, 99% of the workers in America do not have a contract or not under a contract. More often than not, they're what's called at-will employees. And I will tell you right now, the employers don't want you to have a contract because then you could enforce your rights against them. Usually the only contract you have with your employer might be an arbitration contract. And as many as 60 million people in this country today have an arbitration contract, and the majority of those people are unaware what that really means because you just sign off on it when you start your job. And it's put there with your W-9s or your W-2s or your other tax forms, your 1099s, whatever you're signing with them, or I have received the policy manual. There you go. And you may not even realize that you've signed that arbitration agreement. But the courts have said, including the United States Supreme Court has said that that is okay. That you are agreeing to arbitration, even if you didn't fully understand it, you had the opportunity to decide what it was. It's your job to figure out whether or not that materially affects your employment or your rights. So, in closing, arbitration bad. I think it's bad. However, if you're subject to arbitration, you still need to be represented and you still need the assistance of a lawyer to help you in your discrimination complaints, especially in how to select an arbitrator, how to present your case in arbitration, and how to do discovery. Because under the general rules of litigation regarding employment, if you're in state or federal court, you do get discovery. The difference is in arbitration, sometimes you are not allowed discovery. How can you put your case on if you can't gather the evidence? Because most of the evidence is held by your employer. Once again, this is Kevin Baldwin at Baldwin Vernon. If you are in need of an attorney, please give us a call. If you have an arbitration agreement, please give us a call. Let us take a look at it. Thank you very much. Have a good day.